This is the procedure of members' voluntary winding up. One is that a liquidator will be appointed to look at the affairs. You look at the assets and you distribute them, pay off the debts. Then once a liquidator is appointed, the directors no longer have any powers. The liquidator assumes and takes over. So it is the liquidators who will now make the decisions. They will be running the show. A liquidator has the powers in these members' voluntary winding up to accept shares. Where a company is proposed to be wound up or is in the process of being wound up, and the whole or part of the assets of the company are proposed to be transferred to another company, the liquidator of the transfer may, with the sanction of the company, receive in compensation shares or policies or other interest in the transferee company for distribution amongst the members of the transferee company, where you can agree, this is our compensation, and this will only happen where you're transferring to another company. That is what we are talking about, them accepting shares, that there is another company being formed and we're transferring the assets, all of them. And in this case, we have closed this one, we have purpose to open a new one. So in this old company A, we have appointed a liquidator. So we are transferring the assets to company B. So this liquidator can accept shares as compensation or any other interests. So this liquidator also will call for a creditors meeting. If he's of the opinion that the debts may not be fully paid within the period, within the 12 months, then he'll call the creditors and lay the books of accounts, tell them that this is where we currently are at, and find a way to bring the creditors on board with these winding up proceedings. And where the liquidation goes on for more than 1 year. For every year from the commencement, you remember we are given a time period of the 12 months. Ideally, within 12 months, you should have finished up all the work that you are doing. So where it has proceeded and gone over the 12 months, then for every year that this business is being carried out, the liquidator, remember that immediately you appoint a liquidator, we no longer talk about the board of directors. They assume their powers, and they will call meetings for every year that this winding up business is continuing. And where they're finally able to wind up, they will call the final meeting. And the purpose is to lay down the detailed accounts. We have been able to pay off this. These are the costs that we have incurred. If it's transferring, we have successfully transferred to company B. The liquidator has been awarded these many shares or these interests. And this is where the business is done. The books have been looked at. The registrar has been served. If it exceeded 12 months, an AGM has been called. And the books are now ready to be closed off. There's no other business happening. And these detailed accounts of the process from the commencement to the end is what will be discussed. And finally is when you dissolve that company because it no longer has assets. Remember, the directors have already been replaced by the liquidator. It no longer has any business going on. And once it is wound up and it is dissolved, then it no longer exists. So we had said it's either the members who call for a voluntary winding up, which is what we have done, where they'll appoint the liquidator. The creditors can also have their voluntary winding up. And in voluntary, where a declaration of solvency is not made, the creditors take it up. where in voluntary and in it's the members, they declare that they're able to meet the obligations. Where they're not able to do that, and it is voluntary, it's the creditors now who take it up, who take up the whole winding up procedure in order to protect their own interests. And their procedure is, one, the creditors will meet on the day or the day following the next one. We will remember that creditors are invited to these AGMs. So where that resolution is made, that the members want to voluntarily wind up the company, and there's no declaration of solvency. In that meeting, once the meeting is done, the next day or the day after, then the creditors will meet. And once they meet, a notice will be given out. The company should issue a notice to all creditors, and it will be gazetted or advertised in a daily that is, it has a wide circulation, a proper newspaper, so to speak, that reaches basically every corner of the area of jurisdiction. And once the notice is done, the statement of affairs has to be tabled, that the position of the company's affairs, what they have been doing, who they have been paying, the assets they have. And it is tabled down with a list of all creditors and the estimated amounts of their claims. So the statement of affairs is tabled. The creditors are tabled, each with the amount advanced to the company, the amount remaining, the interest on top that has not been paid, as well as how is the company operating, which assets do they have in this winding up that they purposed to do. How did they intend to take care of their business? Once the affairs are tabled, and once the list of creditors matching the amounts owed are tabled, then a liquidator will be appointed. And these are the creditors, remember. They may nominate a liquidator for the purpose of winding up and distributing their assets. Upon the appointment of that liquidator, there is also a committee of inspection. And this committee will look into the books of accounts. It will look into the affairs of the company to enable them to see how will their debts be paid. Once the liquidator is appointed, then their remuneration is also discussed. And it is either to be fixed by the committee of inspection, or where there's no committee, then by the creditors. You see, when it's the members voluntary winding up, then they give the liquidator a chance to acquire shares or interests if there's the transference from company A to company B, or they cater in their costs. So where it's the creditors doing the winding up, then they'll agree how much will they be able to pay off this liquidator that they have appointed. Again, once a liquidator is appointed, the directors cede all their powers. They no longer operate, they no longer transact on the behalf of the company. It's the liquidator that now takes over. It's them who make the decisions from the minute he's appointed. And again, if the 12 months have lapsed, an AGM will be called. If a liquidator is dead or resigns, the creditors will appoint another one until the winding up is done. Then finally is when the liquidator has assessed the company, he has been able to give the way forward, the debts have been paid off, each creditor has been restored to the position they were in before they started trading with the company, and their remuneration is paid, Then they call for that final meeting. They wind up the company, and a resolution is passed that the affairs of the company have been wound up and the assets have been distributed. And the liquidator will notify the court of this resolution that we are now done. There are no more assets in the company's name. There's no one claiming the company owes them anything. And once you pass that resolution of the winding up, then the dissolution happens. So the winding up has to be completed. This is where we are saying, if it extends the 12 months, the meeting, the AGM must be held and the affairs must be tabled. All these issues must be dealt with. And once the creditors are comfortable, their affairs have been dealt with, their debts have been paid, then the final meeting will be called. A resolution that the company has been wound up will be taken to court, and the court now will dissolve the company. And that will be the end of our company A or company B.